to remain is entitled to stand unless, in those very rare circumstances, all the evidence is so great to show that the verdict is inappropriate that, in the language of the Lemon case that has been cited, it amounts to a miscarriage of justice to let the verdict stand. To a great extent, this motion is very similar to the motion that the defense in this case brought at the close of the prosecution's proofs. And that motion was properly heard and not granted. I have reviewed this carefully. Not only did I preside at the trial, of course, but I've had the benefit of the motion to review since on or about December 8th or 9th. I'm not certain when it was actually delivered to me. I cannot say that the verdict in this case is so contrary to the evidence that to allow it to stand results in a miscarriage. This is a case without question, which first of all was circumstantial, as has been recognized throughout the trial, but which a jury could have considered in many ways. But in the final analysis, I'm not satisfied that their verdict is so contrary to the evidence that to allow it to stand amounts to a miscarriage, and the motion will not be granted. All right, Mr. Schaefer, you may proceed. Thank you, Your
Honor. The second motion that has been brought, Your Honor, is a motion for a new trial, and a memorandum has been set forth therein, and is brought on two grounds, or a combination of two grounds, based on the court rule and the statutes as set forth in that motion. Number one, against the great weight of evidence, and number two, a newly discovered evidence. The law is interesting in relation to the against the great weight of evidence, and it's very similar to the arguments previously made, so I will adopt those arguments and go to the newly discovered evidence. This case is a case that was closely followed by this community, and probably was very divisive in this community. And the verdict by the jury came back on November 27th, Friday after Thanksgiving. And someone who is unrelated to the defendant, to the prosecution, or the families of Dee Dee Foley or Tom Foley, came forward on the 28th of November. As set forth in the affidavit and the argument, she was disturbed and concerned about coming forward earlier. She wanted to. She contacted relatives back on February 7th of 2009, talked to them about what she had seen. She lives in a rural area, and she was concerned for her well-being, and she's 70 years old. On the 28th of November, my investigator got a call from the family of Thomas Foley. Apparently, Mrs. Moore contacted the family of Thomas Foley on that Saturday on the 28th of November and related to them that she had information about what happened on February 7th at the Foley residence. On that date, my investigator had phone contact with her. On that Monday, I met with this person after contacting her in my office, had discussion with her as to what she knew and observed on February 7th. This is a person that I had never seen before, had never heard of before, and she related what she had seen on that Monday following the 28th. And on December 2, she returned my office. I had prepared an affidavit to memorialize that which she had told me on that Monday. She had told me in the presence of my investigator on the 2nd what she had seen on the 7th at approximately 4:45 in the afternoon. She was passing the Foley residence when a white car, different than Mr. Brownell's testimony, at a different time at 4:45 versus 4 o'clock, this car was heading outward nose first, not backing out, did not stop at the driveway, and would have collided with Mrs. Moore's car, who was headed east on Girard Road, but for her slamming on her brakes. At the time that this near collision took place, Mrs. Moore made eye contact with the driver, thought that she could recognize this person again, gave a detailed description of this person, made comments as to the circumstance that he appeared that he was high on something, that he was running away from something, and she was disturbed to the point that she called her daughter in South Carolina that very evening. It became clear through the media reports that day and the next day that this is where the Foley murder had taken place. In fact, she went by the driveway the next day or within a day and had seen the yellow tapes at the driveway and made the connection. Due to her fear, she did not report this. She followed the trial in the media. Upon the conviction of Thomas Foley, she felt compelled to come forward, and she did. She has no dog in this fight. She's an independent person. I submit that the four-prong rule for new evidence, for new trials, are met pursuant to the case law set forth. This is truly new evidence. It's not that the defendants sat on their hands in relation to any leads that took place. As set forth in affidavits, my investigator put in approximately 500 hours running down whatever leads existed. And this lead never existed from any source over the 8 or 9 month period that the investigation took place. It is not cumulative. We submit that it may be an addition at a different time, a different car, a different person who came out of that drive between the time period of the death of D.D. Foley. That death time period was between 3 o'clock and 5:30 on the 7th of February. This was in that time period. There should have been no one there at 4:45. Shouldn't have been anybody there at 4 o'clock, but apparently there were people there at that point in time. The actions of this particular person are consistent with someone who was doing something wrong or participated in something wrong at the Foley residence at the time of the murder of D.D. Foley. I submit that because of the circumstantial matter of this case, that this is significant and would give a probable result different by a jury than what took place herein. It is different than the Brownell testimony. In addition, Your Honor, the affidavit of Mr. Korberstein verifies the efforts that have been made, indicating that this is truly new evidence. There was a tentative identification, and I understand the affidavits refuting that, but that was a tentative identification that took place. She believes that she is